Alex here with part 183 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I like to go over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of the 8-year-long high-conflict child custody ordeal that I went through from beginning to end in chronological order. We go into the Supreme Court's my Supreme Court filing, specifically the docketing statement. And this is going to be a video where I have a pretty good mindset going forward. I feel like there's one major thing and one secondary thing that I can recall here. The major thing was I felt like for sure, I felt like it was very, very likely that I was going to win the appeal. One of the things that I was insecure about was the jurisdictional statement. There was a slightly quirky issue with regards to how my judge handled this that gave me some insecurity as to whether or not the Supreme Court would have jurisdiction to hear the appeal. I felt like once I got past that one issue that I would be for sure getting an order reversing. But until I, could see if I could make it past that, I had some, concerns that maybe it would get dismissed. And we're going to talk about that very soon because we're actually going to go into the docketing statement, which is going to cover, it's going to have something in it called a jurisdictional statement. I'm pretty sure it does. I know for sure the opening brief does, but I think it touches on it in the docketing statement. So we'll have an opportunity there as well. The sort of secondary thing that I felt was I was really happy to have a pending appeal on attorney fees because there was drama going on in the lower court. We've got multiple motions that are being filed in the lower court while this appeal is being litigated. So I'm litigating actually 3 cases at the same time. I'm litigating the child custody case, which is the FV08. I'm litigating the writ case, which is the CD13, and I'm litigating an appeal. So all 3 of these cases are going at the same time. And I felt like it was good for everyone to be on notice, the judge and my ex's attorney, that these attorney fees were going to be appealed. And if these ones are going to be appealed, maybe I'm going to appeal, the other ones too. Now, I'm not saying that means I'm going to abuse the court process and just file appeals on anything, anytime. I'm just letting them know that I'm not going to take these attorney fee sanctions lying down. I talk about this in the video, Defense Against Attorney Fees, and I also talk a little bit about this in the video, Attack. Now, in that video, I don't tell people file a bunch of things just to overwhelm your opponent. I tell people, if you have something that has merit, file it. Don't worry about the fact that other things are pending. My appeal on attorney fees has merit for sure because I'm going to win it. But, I'm going to be filing other things, and it's going to seem like, hey, Alex, you're kind of crazy. You're filing all these motions when other motions haven't even been resolved, and you got an appeal still pending. And I'm going to be like, each of these filings had merit. At the time, these things were going on. At the time, I needed relief. And I know that early on in the case, I kind of felt like maybe I should wait until things settle down before I file something new. But all that ended up doing is hurting our child. And when you're doing that, you're not thinking about the best interest of the child. What you're afraid of is your ex's attorney and the judge having a cow because you're a non-lawyer filing too many papers. So, I've mentioned these videos a few times as to why that is an inane way to approach proper person litigants, but it happens. The first one that explains why it happens is called self-representation bias. The second one that explains the wrong-headed idea that a lot of these judges have as to too many filings is covered in the video, End of Filings as Not End of Abuse. And then, of course, we have the problem with meta rulings, which is another video topic. And then, at this point in time, I think I kind of covered all of the dynamics behind what's going on here and my mindset. So we're really going to get down into the nitty gritty when we go into what I have filed. Here we have the docketing statement. Going into this document, some pretty good information here and a warning. You do have to comply with the rules of appellate procedure in preparing this docketing statement, and if you do not do this, your case could be dismissed. Even if even if they do decide to hear your case, it could cause serious delays in your case. So Rule 14C covers what needs to be in the docketing statement and all kinds of other details. But for the most part, it's a fill in the blank, so it's not too difficult to go through. Any portions of this that are not law related, I'm going to go ahead and move through pretty quickly. So, you can see filling in the blank as to what court and who the judge was and the case number and all that stuff. That's like filling out an application. Anyone can do that. Nature of disposition. So I'm calling it an other disposition because this is a special order after judgment, which is covered by the Rules of Appellate Procedure, specifically 3A, subsection B8. Special orders after judgment are really quirky because the case is already closed. In fact, in this particular case, it's long closed. And so trying to get it heard on appeal requires you to kind of get it shoehorned into the special order after judgment category, which is tricky. I talk about that a little bit in the video filing an appeal. They're asking this question here as to whether the appeal raises issues of child custody, venue, or termination of parental rights because it controls how the appeal will go through the appellate process. For example, if you mark the box termination of parental rights, that's going to tell them to, under Rule 17, hold on to the case rather than send it to the Court of Appeals. But I mean, this, for the most part, this is helping them figure out whether they have jurisdiction and also figure out where to send you. Pending and prior proceedings, so I just list all the prior cases. And this is all appeals. Pending and prior proceedings in other courts, so I go ahead and list these other cases which are in the district courts. Nature of the action, so I explain that we share a common minor child of age 9. The court originally awarded physical and legal custody to us jointly. Several years later, the district court made findings inter alia of child neglect against my ex. Inter alia means, among other things, the district court modified child custody and reduced an outstanding amount of medical obligations to a judgment in favor of me and against my ex. My ex was supposed to make payments on the judgment and she failed to do so based on her lapsed payment and the previous history of non-payment of child support and medical obligations. I moved the court for supplementary proceedings in the aid of execution and I filed a writ of execution. My ex opposed the motion, moved to expunge the writ, and asked for attorney fees. The court expunged the writ and denied the motion for supplementary proceeding. The court denied the fees on the expunging of the writ, but granted the fees on the denial of the supplementary proceedings. The fact that the judge did this makes me really embrace the idea that she probably did a meta ruling because the law was consistent with both issues. So she should have either denied both or granted both. The fact that she granted one and denied one is to me a very strong indicator that she was not being a judge or a lawyer. She basically took all of her law school knowledge, poured it out of her head, threw it away, and decided, you know what, 50-50. One of you gets it, and one of you doesn't get it. And that is not how the law works. You don't have to go to law school to do that. I mean, if you're going to sit on the bench and you're going to say, since I don't really know what to do, you're going to get half and you're going to get half, you're going to be pretty quickly chased out because people expect their issues to actually be heard. Sometimes one person is right and one person is wrong. You can't just say, hey, anytime people come in front of me, I'm just going to split it in half and give them half. That is not what judges and lawyers go to school to do. That's just what random people do. And even then, only sometimes. Going into the next section here. Again, guys, I talk about this in the video meta rulings. It's a serious issue in child custody cases. We have the issues on appeal. State specifically all issues in the appeal. And then here, it's just the issue of the sanctions. Pending proceedings in this court raising similar issues. I don't have any that I know of, so I don't put them in here. If you do put other cases with similar issues here, what the Supreme Court will sometimes do is consolidate them. So they'll combine the cases together and they'll deal with them at the same time. Constitutional issues. None. I don't really rely. If I had some to rely on, I would have cited them in my lower court case as well, but I didn't. Other issues. Does this appeal involve? I think these are special issues that control timelines, but in this particular case, there's none. Trial, whether you had a trial. We didn't have a trial. The judge just summarily ordered those attorney fees, if you guys remember. So she denied both motions and summarily ordered attorney fees on one of those motions. It's a little tricky here because she did have the relocation hearing with a question mark after the fact, but that really wasn't about the attorney fees because the only thing that was an issue at that point was the amount of the fees, and I filed non-opposition anyway. I didn't oppose those fees. So it was really just about relocation, which was the point of that hearing. So that's why I put down that there wasn't one. Disqualification. You can sometimes ask for a justice of the Supreme Court to be disqualified, and I didn't have any intent to do that. Timeliness. They want to know the date of the judgment or order that you're appealing from, and they also want to know the notice of entry when both were filed. And then they're going to count the timeline from the notice of entry. If the time for filing was told, then you have to put in here how it was told. Certain documents will toll the filing, the deadline. If you want to know more about that, I think it's covered in filing an appeal, but there might be another video on the topic where I go over tolling. Anyway, some motions when they're filed, they toll when you can appeal, and not only does it give you an additional amount of time to file an appeal, but you're actually not even really allowed to file an appeal until after that other thing gets resolved. The date that the notice of appeal was filed, so they want to know when you filed the notice of appeal. They want to know what rule governs the timeline, so I cite Rule 4, subsection A1, which is, I think, 30 days. I'm like 99% sure it's 30 days. There are some oddball situations where you have less time to appeal. For example, an appeal from a small claims judgment is 5 days. It has to be, done very quickly. Substantive appealability. So here they're looking at issues. So they want to know what particular issue is before them that allows you to appeal. And so I'm citing Rule 3A, subsection B8. I think this is the special order after judgment rule. And then I go into the case law here. So the case law that controls specific to child custody is Lee versus GNLV Corp. They've used this before in child custody situations. Actually, yeah. Well, no, wait, this is not a child custody one. This is the one that discusses attorney fees and costs. Okay, so never mind, scratch that. So in Lee versus GNLV Corp, they explain that attorney fee awards, cost awards are post-judgment issues that you can appeal after the judgment has been entered. And that's what I'm doing in this case. I'm appealing an award of attorney fees. List all the parties involved in the action, consolidated actions in the district court. So it's me and my ex. Brief description as to each of our claims. And this just goes into the modification of custody and stuff like that. Did the judgment or order appeal from adjudicate all the claims alleged? Yes, it did. Now, this is what's interesting, because if you remember, the judge didn't deal with these all at the same time. She granted their request for attorney fees, but she didn't set the dollar amount. And so at the time that she did that, I could not appeal because she hadn't disposed of the entire issue, which was, what's the dollar amount of the fees? How can you claim you're an aggrieved party if you don't have to pay an attorney fees? Like, the judge says you have to pay attorney fees, but they haven't told you how much. So you don't know how much to pay. So you really do need to be aggrieved. You really need all those issues resolved before you can actually, file an appeal. And I don't see the jurisdictional statement in here. So maybe it comes up in the opening brief, guys. And if that's the case, then sorry about that. We'll just hang in there until I get to that video and we'll talk about that in detail. But I don't think it's come up yet. Did the court certify the judgment or order appealed from as a final judgment pursuant to 54B? I guess the judge did. I don't really know exactly what this means. I haven't done enough research to really understand it, but there must be some way that a judge can certify something as ready for an appeal. I don't know. Did the district court make an express determination pursuant to the rule that there is no just reason for delay and an expressly direct for the entry of judgment? No. If you answered no, explain the basis. Oh, and then I'm just saying that this order is independently appealable as a special order after judgment. So this is what I've been talking about the whole time. Then I have to attach file stamp copies of the following documents. And they want like the latest complaint, counterclaims, tolling motions that were filed, orders from the court. These are documents they're going to look through to determine if they have jurisdiction on the appeal. So at this point in time, they're not trying to decide if you won or not. They're just trying to decide, do we even have jurisdiction? Do we even have the power to even consider this? Because a lot of times people file appeals and they don't. And so they need to go through this document to find this out. Verification. So I'm just verifying that I have prepared this document. Certificate of service. I'm indicating that I mailed this document to my ex directly. And then, guys, these are documents we've already gone through. So as with my standard policy for the My Docket series, I'm not going to go over documents multiple times in the My Docket series. You can always go down into the description below, click on the link, download it for yourself, take a look. And if you see something in there that jumps out at you, let me know and I'll post something down in the comments and I will address whatever it is that you want me to talk about down in the comments. But each and every one of these filings I've already gone through in the My Docket series. They're just duplicates of that filing. In fact, you're not really allowed to bring in new evidence, even if you wanted to. And I talk about that in the video Record on Appeal. I think that's what it's titled. So definitely take a look at that video and I talk about the record on appeal and what it's limited to. Notice regarding deadlines. So this is a document from the clerk of the Supreme Court. She's just letting me know that I have 15 days to pay the filing fee on this case, and I do pay it on time. I pay it within 15 days. Pretty standard automatic piece of paper. I don't even think they manually do this. I think it just automatically checks if you've paid it, and if not, it just sends it to you. We have a notice of disassociation of counsel. So you've already seen this document in the previous video. This is the same exact notice, only this time he filed in the Supreme Court of Nevada to let the Supreme Court know the same exact thing that he was letting the district court know, which is that he is not representing my ex on this appeal. Notice that respondent is improper person. So the timing on this was pretty close, but I didn't know if this lawyer was going to tell the Supreme Court if he wasn't representing her. So I went ahead and filed this notice. letting the Supreme Court know that my ex is an improper person. And then I have Exhibit 1, which is probably that same exact notice of disassociation. Let's go take a look. Rule 5, certificate of service indicating this document was served upon my ex. List of exhibits. Exhibit 1. Okay, so it's not the notice, it's an email. So what's going on here? What is going on here? Okay, yeah, so I tell him, okay, so I send a communication to him first. I'm telling him, hey, Rule 9A, subsection 1A requires me to confer with you on the transcript request that I intend to file. And that's true. The rules require you to confer with the other attorney on the transcript request form. In this case, I intend to file a certificate that no transcripts are being requested. I'll wait until December 23rd before I file one in this case you have some input. So I'm just letting him know, hey, by the way, guys, I have a video on this topic, communicating with lawyers. Please watch my video on that topic, because this is how you have to do it. A lot of times you'll kind of want to get them to have an emotional connection to your case and like be the hero in your story and like dump your ex and turn against her and like backstab her. It just drives them crazy. They don't do that. But they do need to communicate you when the rules of civil procedure require it. And so I explain in the video, communicating with your ex's lawyer or communicating with lawyers is something like that. Definitely take a look at it. I forgot the title verbatim, but I'm pretty close. Anyway, he responds, Mr. Falcone, we do not represent Ms. Farrar in the appeal you are referencing. Please forward all communication in that regard directly to her. And then I reply to him, thank you. I will not send any further communication regarding this case. Done. Order from the Supreme Court of Nevada. Counsel for my ex has filed a notice of disassociation of counsel, indicating that all pleadings and correspondence should be sent to my ex personally. This notice does not comply with rules of appellate procedure 46 subsection E3. Accordingly, the Supreme Court is denying his request to withdraw without prejudice to file a proper motion that is consistent with the rules of appellate procedure. The Supreme Court doesn't play around. You must comply with their rules. They do not care if you're not an attorney. They do not care if you are an attorney. So they're just telling this attorney, hey, you screwed this up. File a motion consistent with the rules, just like everyone else. Next document. Certificate that no transcript is being requested. So I am stating as I had intended to, or I'm filing as I intended to file a certificate to the Supreme Court indicating that no transcript is being requested. I wonder if I have a video on this topic. I'm pretty sure I do, and I think it's titled Transcript Request Form. I'm pretty sure, if I don't, it might be under Court Reporters, possibly under Court Reporters. Anyway, since I don't have a transcript for the Supreme Court to consider, then I'm just letting them know by filing the certificate, specifically letting them know that I'm not forgetting to file a transcript request form. I expressly have no intention to do that because I don't need a transcript. Rule 5, certificate of service. By the way, guys, it's not optional. It's not optional. If a transcript is relevant to your case, you have to request it and send it up there. You can't just not feel like doing it. If you're not asking for a transcript, it's because it is not appropriate for any particular transcript to be before them. The issue that you're bringing to them has just been decided on paperwork. You know, that's why I'm doing this. If you file something like this when there was like a full-blown hearing and that was relevant to the issues, you're going to lose your appeal. They're going to file an order affirming, and they're going to say that you failed to send the transcript that they needed. So you have to really figure out, whether or not any of the hearings that you went to are actually relevant to deciding the issue, because if they are, you must get the transcript. I'm going to move on to, I think that's everything. Going into the aftermath, I filed, let's see here, it looks like 1, 2, no, wait, wait, 1, 2, 3. 3 documents. They were not all free filings. 2 of them were free filings, but one of them required a filing fee. But actually, I covered that in the lower case. Yeah, I did. So at this point in time, we're at $0 in fees. My ex's attorney filed, it looks like, 1 document, and she incurred $0 in cost because that was also a free filing. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney specifically said, I am not going to represent her. So she has $0 in attorney fees as well. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.